Alrighty. Before the lunch break, I'd gone through the first of the 5 stages I outlined in namely an introduction to what we say are the issues in the case and our response to them. Can I now move to stage 2, which is to analyse the state of the case law, the Luxembourg case law, prior to Chavez-Vilches. I do this to make good the proposition that the Zambrano right has always been conceived from the outset as protecting actual departure from the union and nothing less. To do that, can I take the court back to Zambrano? I appreciate the court is familiar with it and has already seen it this morning, so I'll do it very briefly. But there's just one short passage I want to go to in order to make a point. It's in volume 1, tab 12, beginning at MS 859, the relevant passages are MS 912. And just while the court's turning that up, it's worth recapping at this stage that, of course, the factual scenario in Zambrano itself was that the court was faced with a situation where both parents, the mother and the father of the child in question, were third country nationals with no right to reside in Belgium. So that's slightly different from the scenarios that the court deals with later, when it examines either family unit cases with usually one parent with a right to reside and one without a right to reside, or a single parent family situation where there is a father somewhere else, perhaps in the country, but not residing as a family unit. So here, both parents had no right to reside in Belgium, absent the Zambrano right, and there was therefore a situation of, in effect, a guaranteed departure from the union if no right was recognised. So that's the factual scenario faced by the court. I just take the court back to paragraph 44 at the bottom of the page. What, of course, the court says there is this: it must be assumed that such a refusal would lead to a situation where those children, citizens of the European Union, would have to leave the territory of the Union in order to accompany their parents. So that's a refusal of a right of residence. Similarly, if a work permit were not granted to such a person, he would risk not having sufficient resources to provide for himself and his family, which would also result in the children, citizens of the Union, having to leave the territory of the Union. In those circumstances, those citizens of the Union would, as a result, be unable to exercise the substance of the rights conferred on them by virtue of their status as EU citizens. So what I say about that passage is that 2 separate scenarios are identified. First of all, and perhaps most obviously, the court focuses on the right to reside issue, and it says that the refusal of a right to reside would mean that EU children would have to leave to accompany their parents. Again, in the factual context I've just outlined, that of course must be true. So the court was there considering, as I say, a guaranteed departure, with no question but that the EU children would leave. Equally important to note at this stage that the court wasn't examining any countervailing issue of public interest. So in Zambrano, unlike, for example, CS Morocco and Rendon Marin, cases which follow later, there's no question of, for example, the impact of criminality on the part of the third country parent and how that plays into the issue about whether a Zambrano right needs to be recognised. So it's a quite straightforward situation for the court. The second scenario, then, that the court considers is the impact of having no ability to work. And the court drew, again, the perhaps obvious conclusion that if there wasn't a right of work granted, then there would be no sufficient resources to provide for the third country national and the family. And therefore, again, as a matter of practice, and that's a term that does come out in some of the case law, the family would be required, and the EU citizen children in particular, would be required to leave. So unsurprising, we say in those circumstances that the court insisted on a right to work. But that is the fairly stringent basis on which Zambrano exists as a principle and on which the later cases then develop. I'd also ask the court to note this: it is, of course, a relatively sparse consideration of the nature of the right, given the far-reaching nature of this particular right. There's been a lot written about Zambrano, as the court will be aware, since the judgment was handed down, and a lot of the criticism stems from the difficulty in understanding precisely how far the right is meant to reach. So the cases which come afterwards are very much dealing with an attempt to place limits on the right and to understand when exactly it applies.
Well, is it necessary to say it places limits? It may simply be refining the principle generally.
Well, I'd accept that, yes, of course, yes. The principle is stated in broad terms in Zambrano. I would say without particularly clear limits, but in any case, in any event, yes, the court in later cases seeks to refine the application of the principle to particular factual situations. So against that background, in the Zambrano case itself, can I then take the court to two cases? Again, it's seen this morning, but if I can make particular submissions about them. First of all, Dept, and that's, again, in Volume 1, Tab 6, MS 652 is where the case begins.
Do we know that that's the correct way to pronounce it?
It's a very
I've
difficult
been
question.
worrying about this all morning, along with a lot of other things, of course. But
Well, my lady, my Turkish isn't very good, to say the least. Indeed, it's non-existent.
well, I would love to know what the correct way of pronouncing it is, and then
Can we make some inquiries and come back to you?
somebody is saying yes.
Miss Mole is saying Dept, and I certainly trust her on the pronunciation.
Good.
I go for Dept.
Good. Well, that's wonderful.
Well, Eddie, so
Thank you.
Dept. And the facts of the Dept, we say, are very similar, indeed materially identical to the facts of the Shah case. So it involves a non-EU national man who marries a citizen of a member state, Austria, in that state, and has 3 children who have citizenship of that state. One can see that quite clearly from paragraph 6 of the Advocate General's opinion. And perhaps just worth, again, looking at this to see exactly what it was the court was dealing with. So this is MS 660, AG6. More specifically, in the first case, there were 3 cases joined in the main proceedings. Mr. Murat Dept, the Turkish national, entered Austria illegally in November 2001, married an Austrian citizen in July 2003, by whom he has had 3 minor children in 2006, 2007, and 2008, who are all also Austrian nationals. I pause there. It's not a babe in arms case, but the children are still quite young. The date of the Advocate General's opinion was the 29th of September 2011. So at that stage, the children are aged variously 5, 4, and 3. So quite young children.
And in fact, at the date where he's making the application to the Austrian authorities, they're younger still, aren't they?
They are younger still. So indeed, my Lord's absolutely right. At that stage, they are indeed babes in arms. Or at least one of them is. So my Lords, my Ladies, that's the factual background. Can I then just again, to give some context to the issue before the court, go to AG 11 over the page at 661. And the Advocate General, this is Advocate General Mengozi, said this: hearing these cases, the referring court is uncertain in view of the above-mentioned judgment in Zambrano about the conditions in which Union citizens would, within the meaning of that judgment, have to leave the territory of the Union in order to accompany the members of their family who are nationals of non-member countries and would therefore be deprived of the genuine enjoyment of the rights conferred on them by virtue of their status as citizens of the Union. Furthermore, whilst recognising that that's the Citizens Directive, Directive 2004-38, is not applicable in the 5 cases in the main proceedings because the Union citizens concerned have not exercised their right of free movement, the referring court asks whether, since that directive favours the maintenance of family unity. Now, I pause there. The reason I'm going to this passage and some other passages is because what the additional context it gives to the court's consideration of family unity at paragraph 68. It should be taken into account, so whether, since that directive favours the maintenance of family unity, it should be taken into account so that it might be held that the impossibility of leading a family life in a member state could in itself deprive Union citizens of the enjoyment of the substance of the rights which they derive from their status. So there was before the court an issue as to whether an impact on family unity, family life rights in that broad sense, could suffice to engage the Zambrano principle. And that's why one sees in paragraph 68, for example, and 69, of the judgment, the issue of family unity being examined in that way. So the Advocate General then sets out some more details of the facts, some more details of the background case law. At AG 16, page 664, one sees the analysis beginning under Article 20 in Zambrano. Again, over the page 665, AG 24, one sees reference to the McCarthy case. McCarthy was the first decision after Zambrano to consider Zambrano. It involved a woman with dual nationality within the host member state seeking a right of residence for a third country national partner, husband, I think. And the court held that Zambrano wasn't engaged there. So there's some consideration of that in the paragraphs which follow. Can I then ask the court to turn up page MS667? And there's a passage I'll read, but before I do, perhaps I could ask the court to read paragraphs AG34 and AG37, and then I'll pick it up again after that. I'm grateful. Can I then pick it up from AG38? I'll just read these passages. It follows from the position taken by the court in these two above-mentioned judgments, and particularly from the reasoning put forward in McCarthy, that the right to respect for family life appears to be insufficient in itself to bring within the scope of union law the situation of a union citizen who has not exercised his right of free movement, and or, as the case may be, has not been deprived of the genuine enjoyment of one of the other rights set out in Article 20, Para 2, B to D, TFEU. Then this position can be explained less by respect for the wording of Article 20, Para 2, in which the list of rights enjoyed by union citizens is clearly not exhaustive, than by the concern that the union's powers and those of its institutions should not encroach on those of the member states in the field of immigration or on those of the European Court of Human Rights in the field of protection of fundamental rights in accordance with Article 6.1 and 51.2 of the Charter. With particular regard to family life, the protection afforded to it by these three legal orders, national, union and treaty law, proves to be complementary. Thus, in the case of a union citizen who has exercised one of the freedoms laid down in the TFEU, the right to respect for family life is at present protected at national level and in union law. I pause there, of course, under Article 7 of the Charter. In the case of a union citizen who has not exercised one of those freedoms, that protection is provided at national level and in treaty law, of course, being the Convention. It cannot therefore be ruled out that in the cases in the main proceedings, the refusal to issue a residence permit and or the expulsion orders made against any of the claimants in the main proceedings, parent, child or spouse of a national of a member state, may constitute a breach of respect for family life guaranteed by Article 8 ECHR. However, such an infringement would stem from the Republic of Austria's obligations under the ECHR and not as a member state of the Union. Jurisdiction for examining the infringement would lie with national courts and tribunals, and as the case may be, the Strasbourg Court.
But that's a particular approach to the relationship with Strasbourg, isn't it? That they should be separate streams running in separate rivers.
Yes, my lady, but it's a separate approach which is, of course, informed by the point in Para 40 of the Advocate General's opinion, which is that where you are engaging EU law, then you get within the scope of the equivalent protection in Article 7 of the Charter. But where you're not, then you go down a separate stream. And my lady, it picks up in my submission on a point made by my Lord Sales in argument this morning about the possibility of Article 8 engaging in some of these cases. Of course, there was an Article 8 application which failed in Patel. There was one made before the birth of the child in Shah. There's not been a separate one. Mr. Malik is absolutely right to say that Article 8 couldn't have been raised in the appeal process on the EU appeal. But of course, there's nothing to stop a separate application under Article 8 being made at a later stage. And indeed, the court may have picked up on the fact that there was a third appeal in the Court of Appeal, Baruisa, and the court, Baruisa represented himself. The court made certain observations about the fact that he might have an Article 8 claim, a good Article 8 claim. He did, in fact, make an application. I've taken instructions and the claim was granted, so he was granted Article 8 leave. So there are scenarios where some of the facts that play out in these sorts of situations will engage the protection of the Convention and domestic immigration law, which don't engage the protection in my submission of EU law. And that's illustrated, as I say, by the results in these cases. So the conclusion I take from those two paragraphs is, first of all, the right to respect for family life is insufficient to bring an EU citizen who's not exercised free movement within the scope of EU law. But critically, secondly, that's because of a question of competence or jurisdiction. That's less about the wording of the actual TFEU provisions in question than about the different competences of EU law, the Strasbourg system, and indeed domestic law. So the limitation of the Zambrano principle to situations of actual compulsion to leave, rather than protecting family life rights, is explained by a need not to impinge on those areas of competence of the member states, as well as the work of the Strasbourg Court. Now, in my submission, that is the rationale that one sees behind the discussion of family unity and family life when it's picked up in the judgment at paragraph 66 and following. Again, the court's obviously seen this in some detail this morning, but can I just, with that background, go back to it? It's at MS 686. At para 66 at the bottom, the court begins with the usual recitation about there being it's put a requirement, it follows that the criterion relating to the denial of the genuine enjoyment of the substance of the rights conferred by EU citizen status refers to situations in which the union citizen has, in fact, to leave not only the territory of the member state, which is national, but also the territory of the union. So it's a factual assessment. Then, over the page at 67, one sees the notion of specificity for the first time in the Luxembourg case law, specific in character in as much as it relates to situations where, although there's no subordinate legislation which is applicable, a right of residence may not exceptionally be refused. And then, of course, paragraph 68, where the court says this: consequently, the mere fact that it might appear desirable to a national of a member state for economic reasons or in order to keep his family together in the territory of the union for the members of his family who do not have the nationality of a member state to be able to reside with him in the territory of the union is not sufficient in itself to support the view that the union citizen will be forced to leave if such a right is not granted. That finding is admittedly without prejudice to the question whether, on the basis of other criteria, inter alia by virtue of the right to the protection of family life, a right of residence cannot be refused. However, that question must be tackled in the framework of the provisions on the protection of fundamental rights, which are applicable in each case. That's why I went back to the Advocate General's opinion, because that now, in my submission, makes sense. What the court is saying is it may well be, whatever the position in EU law, that the factual scenarios that are arising in these cases are sufficient to engage the protection of fundamental rights provisions. But if you're not engaging EU law because you're not exercising free movement, it's not going to be in the context of the Charter. It will be within the separate legal framework of Convention rights and Article 8 in particular. There's then further analysis, which in my submission...
Does that make a great deal of sense from the point of view of the Court of Justice to exclude the Charter and bring in the Convention?
Well, in my submission, my lady, it does, for this reason. The key point about the Charter is that it only applies where EU law is engaged or where EU law is applied. And what is absolutely clear from Article 51.2 of the Charter is that it, and indeed the many statements of principle from the Luxembourg Court, is that it can't be used as a means of expanding the competences of the Union or expanding the scope of EU law. So given, and again I come back to the point I made in opening before lunch, given that Zambrano exists at the boundaries of EU law, because there's no exercise of free movement which would classically bring you within the scope of EU law, and you are therefore in what would normally be a purely internal situation, then it's absolutely critical for the court to say, well, we can go this far but no further, where the child or dependent adult's rights, as the case may be, are at risk, at serious risk of being infringed, or rather are infringed because of actual departure, then EU law will step in a Zambrano exceptional way to protect the situation.
Well,
but many of these cases aren't like that. Sorry.
That would dispose of the Article 21 point, but what about Article 20?
Well, my lady, with Article 20, the focus is on the rights as a citizen. Of course, there is a reference to free movement within Article 20 as well, but there's also the reference to, for example, consular protection, European Parliament voting rights, and so on and so forth. The court, certainly in its judgments, hasn't gone that extra further step and examined the degree to which it might be possible to exercise some of those matters externally. Of course, consular protection would be a situation which would only ever be exercised in a third country anyway. But the court hasn't gone that far. It's looked for the purposes of Zambrano at departure from the Union. If you are forced to depart from the Union, if you have no other choice, then EU law in those circumstances will step in, but not otherwise. I hope that answers my lady's question.
Very much.
So just to pick up then the analysis which follows, because it picks up on this at paragraph 70 and onwards, as a preliminary point, the court says, it must be observed that insofar as Article 7 of the Charter contains rights which correspond to Article 8, the meaning of Article 7 is to be the same as that laid down in Article 8 as interpreted by the case law of the Strasbourg Courts. However, para 71, it must be borne in mind that the provisions of the Charter, according to Article 51, 1 thereof, address the Member States only when they are implementing EU law. Under Article 51.2, the Charter does not extend the field of application of EU law beyond the powers of the Union. So this is the point I was just making. Or modify powers and tasks as defined by the treaties. Accordingly, the Court is called upon to interpret, in the light of the Charter, the law of the European Union within the limits of the powers conferred on it. And there's obviously reference to authority. Thus, in the present case, if the referring court considers, in the light of the circumstances of the disputes in the main proceedings, that the situation of the applicant in the main proceedings is covered by EU law, it must examine whether the refusal of their right to residence undermines the right to respect for private and family life in Article 7. On the other hand, if it's not covered by EU law, it must undertake that examination under Article 8. And it makes the point that all member states are, of course, party to the Convention itself. My ladies, my lords, can I take 5 propositions from those passages, please, and just headline? First of all, it is departure in fact which the Zambrano principle protects. That's paragraph 66. Secondly, the right is a specific and exceptional one. As I say, this is the first time the analysis occurs in quite those terms. That's paragraph 67. Thirdly, the desire for family members to stay together for financial reasons or for reasons of family unity is not sufficient to give rise to a Zambrano right. That's paragraph 68. Fourthly, family life rights take effect in a different legal framework, which reflects the passages in AG 38 to 40. Fifthly, I say that's reflected then in the court's judgment in paragraph 71 to 72. Again, my ladies, my lords, stepping back for a moment, those points all demonstrate the very narrow approach to the engagement of protection under Article 20 through the Zambrano principle. The court was expressly asked, one can see from the Advocate General's opinion, if it was about something more than just protecting against expulsion. It was asked about the impact of family life rights, but it found that it wasn't there to protect that particular issue. My lords, my ladies, the second case at Luxembourg level I was proposing to take the court to, again briefly, is the case of O, which the court has also seen this morning. That's, again, Volume 1, Tab 10. And like Mr. O, I think I'll stick to the word O for this case and not the full title. This, of course, is the case about, I should say the reason I go to this case is for the proposition that the existence of a right of residence for a parent with care is a highly significant factor. We know from Chavez Vilches it's not the only factor, but O demonstrates that it is very important. So the fact of the case, as the court will recall, were that there were 2 non-EU nationals, 2 women who married 2 Finnish men and each had a child with them with Finnish nationality. They later separated and settled with new non-EU spouses with whom they had a further child who did not have EU citizenship. And the third country national new fathers applied for residence permits. One can see that from the headnote. Important to note here that the mothers in question had a right to reside in Finland, so there was no question of those mothers having to leave. And again, one sees how that is played out in the Advocate General's opinion and in the court's consideration. Again, this is a case where the Advocate General's opinion is important and is specifically endorsed in one passage in the court's judgment. Can I take the court to the relevant parts, which begin at MS 825? Just to make sense of these passages, S and L are the mothers involved. I'm looking now at paragraph 41 on page 825. Admittedly, it is possible that S and L might choose to follow their respective spouses to their countries of origin in order to preserve the unity of their family life. The fact that their children have union citizenship cannot amount to putting them under house arrest in the territory of the European Union when they have been invested with full parental authority by the judicial authorities of the Union itself. I pause there, of course. Mr. Drabble is right to say that the word choice hasn't been used in the court judgments in any situation, but it is rather the flip side of the coin of compulsion, as my Lord Sales put it. And one sees that behind all these cases there is always an examination of, is there a true obligation to leave? It doesn't have to be a legal obligation, maybe a practical one. Or is there something more like a situation of choice at play? And of course the Advocate General, in referring to house arrest and full parental authority, recognises in my submission the very practical point that there may be very, very many reasons why in a particular case a parent will decide to take their children out of the territory of the Union. It may be for educational reasons, maybe for cultural reasons. It doesn't give rise in each case to a breach of Article 20. The Advocate General then continues, in any event, if they choose to leave, which in my view seems unlikely, particularly in one of the cases for the reasons set out below, the young children who are Union citizens would indeed have no other choice but to leave the territory of the Union and consequently lose the enjoyment of the rights conferred on them as citizens of the Union. However, in my view, departure from the territory of the Union would be freely decided by their mother for a reason linked to the preservation of family life and would not be imposed under the implementation of national legislation. If we refer to the principles set out by the court in Deretchi's case, it does not seem to me that such a reason can suffice to constitute a breach of Article 20. In that case, the court gave a particularly restrictive interpretation of the criteria set out in Zambrano's case, and it refers then to paragraph 68. Then this at paragraph 44. The reasons linked to the departure of the citizen of the Union from its territory are therefore particularly limited in the case law of the court. They concern situations in which the Union citizen has no other choice but to follow the person concerned, whose right of residence has been refused, because he is in that person's care and thus entirely dependent on that person to ensure his maintenance and provide for his own needs. Now, it's that paragraph 44 which is, of course, picked up by the court in paragraph 56. And then, just over the page, perhaps one passage might be relevant to see. It says, it's page 826, paragraph 51. It is true that the presence of the second child, so that would be the third country child, is liable to influence the mother's decision to follow her spouse to his state of origin, hence forcing the child with Union citizenship to leave the territory of the Union. However, as we have indicated, such a consequence would arise from the deliberate decision of the mother and would not be imposed by the implementation of the national legislation. There's repeated reference to national legislation by the Advocate General, which emphasises the importance of examining whether there is a parent with care who has a right to reside and can look after the children. But there's also a recognition there that there are difficult choices to be made, but they don't engage necessarily the protection of Article 20. I said this is, well, before I move on, can I make three submissions about those passages and then I'll go to the court's judgment. The first one is this: in a family unit case, where the remaining parent has a right to reside in the home member state, this will normally indicate that any departure from the EU is a choice. On repeated occasions, the Advocate General makes the point that national legislation is not imposing a requirement to depart. That's plainly a very significant and key part of his reasoning. Secondly, the court recognises that parents invested with full legal authority can make choices based on family life. I've already made that point in going through the passages. They don't all, of course, engage Article 20. And then thirdly, and really flowing from those points, Article 20 is engaged when the EU citizen has no other choice but to follow a person with no right to remain in the EU, because he is in that person's care and entirely dependent on that person to ensure his maintenance and needs are met. And just to pick up on that last point, the point about entire dependence, which is the phraseology used in paragraph 44, is important because it shows why there's no choice. The parent in question meets all the needs, financial, legal and emotional, and there's nobody else who could step in to meet them, then clearly the child will have to leave.
I mean, what are we getting? You're spending a lot of time on the Advocate General's opinion in O.
Yes, my Lord,
There's a case against you as things have moved on.
of course.
And we're not concerned with the Advocate General's opinion, we're concerned with
My Lord,
Chavez.
My Lord, there's two reasons why I go to the Advocate General's opinion in a little detail now. One is because it's then picked up by the court itself in paragraph 56 and endorsed.
Well, some of it.
Some of it is. Paragraph 44 is endorsed. My Lord, the second reason is that O is itself applied later in Chavez-Vilches itself. So in understanding in my submission what it is that Chavez-Vilches actually does, it's important to see what the position was immediately before and what is then carried forward by the court. But that's all I wanted to say about the Advocate General's opinion. Can I take the court to the relevant passages in the court's judgment? They begin at MS 840. And, my lords, my ladies, I can take this rather quicker because the court has seen all of this today, so I don't need to go through it again. It's already been presented to the court. But the relevant passages are really at paragraphs 50 through to paragraph 57. Can I make 5 submissions based on those passages? First of all, the court reiterates the exceptional and specific nature of the test, even for children cases. One takes that from paragraph 55. Secondly, the court highlights the significance of the right to remain of the mothers. That's in paragraph 50. This is important because it shows directly in a case concerning a family unit that the fact that there is no legal obligation to leave is important in deciding whether compulsion exists or whether it's properly to be considered as a situation of choice. And that's also the answer, in part, to one of the points made by the Air Centre, which is that one has to look at the question to be answered from the situational perspective of the child, and as I understand it, they say the child only. In my submission, that's not correct. One has to look at it from the position also of both parents, because where there is one parent who has a right to reside, the court has said that that is an important factor. The third point is that it stresses that family life or family unity does not give rise to a Zambrano right. Again, see the discussion in paragraphs 51 and 52. But significantly, fourthly, for what comes later in Chavez-Vilches, it does emphasise the importance of considering all the circumstances. That's paragraph 53. So it's a broad, even by the time of Chavez-Vilches, it was a broad, factual-based assessment. And then fifthly, paragraph 56 specifically endorses the Advocate General's observations at point 44. My ladies, my lords, that's what I was wanting to say about the cases before Chavez-Vilches, Owen Direcci in particular. Against that background, can I move to stage 3 of my submissions, which is to examine what was said in Chavez-Vilches itself. And in my submission, Chavez-Vilches has to be seen against that particular background. The case, again, it's volume 1, tab 5, and the case begins at MS 606. The court's already been shown the facts. The key point is that the different cases that came before the Dutch courts and were then referred to Luxembourg were all single-parent family cases. So they all involved a third country national mother with care, primary care, of a child who had the citizenship of the Netherlands, who was Dutch. And the position of the fathers varied. In some cases, the father was not even present in the jurisdiction. In other cases, there was some contact, but never very much contact. So it's a different sort of situation. It's not the family unit situation that one has in Direcci or, in the particular circumstances, in O. These are single-parent families. And that does inform slightly the approach in my submission to the factors that are analysed and that are set out, and also, of course, to the issue of family unity. The family unity debate wouldn't apply in exactly the same way in a Chavez-Vilches case, because the unit is constituted quite differently. There's no question in a number of the Chavez-Vilches situations of the father actually being able to take care of the child. Again, you've seen reference, and there's reference made in the head notes, to the position in the Dutch administrative process, which referred to the position where the father was in prison, hospitalised or dead. Absent those situations, the burden was on the mother to demonstrate dependency. But just to prove exactly how strictly that was applied in the Netherlands, can I ask the court to turn up the Advocate General's opinion, MS 620. And one sees just there in paragraph 55 a little more detail about those administrative processes being set out. again reference to dead, hospitalised or in prison. Paragraph 57, there's then reference to the position taken on applications for residence permits. And then over a few pages to some of the, just two footnotes in the Advocate General's opinion, which again are significant for showing how strict the situation was. MS 635, footnote 28, Advocate General Spunar points out this: I should like to point out that, as is apparent from the documents before the court, according to Netherlands administrative practice, where a father cannot be traced, has serious physical impairment, has inflicted domestic violence on the mother, has been placed in a specialist institution in order to receive long-term treatment, or has not had any contact with the child for a long time, it is considered it would not in fact be impossible for him to care for his children. And then 29, it is apparent from the documents before the court and from the observations submitted at the hearing that in order to prove that the Netherlands father cannot care for the child, the mother, who is a third country national, who has primary care, must institute, even against her will, family law proceedings in order to establish the inability of the father to care for the child. So it's an extremely stringent process in the Netherlands that was being examined, and it was being said to be compatible with Article 20. And in my submission, in those circumstances, it's hardly surprising that the court would want to lay out some quite clear criteria for how to approach this question. The questions asked by the referring court are reframed in the usual way at paragraph 59 of the judgment. I'll just take the court there, paragraph 646. So page 646.
Sorry, page?
646, my lord.
Thank you.
I'm so sorry. We'll see there by the first and second questions referred, which can be examined together. The referring court seeks in essence to ascertain whether Article 20 must be interpreted as precluding a member state from refusing a right of residence in its territory to a third country national parent responsible for the primary day-to-day care of a child who is a national of the member state, when it cannot be excluded that the other parent, who is also a national of that member state, might be able to take charge. The referring court seeks to ascertain whether the fact that the child is not entirely dependent legally, financially or emotionally on the third country national is relevant to that issue. Then over the page, again, and the court has seen some of this analysis already.
That's squarely based now on Article 20.
Squarely looking at Article 20, that's right, my lady. Squarely looking at Article 20. Because, of course, again, here there'd been no exercise of free movement, so the Citizens Directive could not be engaged.
And the phraseology there, not entirely dependent, that seems to echo, is this right, what was said in O?
Absolutely,
about, so they seem to be looking, is there some qualification to what
Exactly.
seemed to be a very strict approach in O?
My lord, that's absolutely right. And one sees reference to O in paragraph 68 of Chavez Vultures. Paragraph 68, the court says, in that regard, it must be recalled that in O, paragraphs 51 and 56, of course, paragraph 56 itself endorsed paragraph 44 of the AG's opinion. The court held that factors of relevance for the purpose of determining whether refusal to grant a right of residence means that the child is deprived of the genuine enjoyment, and so on and so forth, include the question of who has custody of the child and whether the child is legally, financially or emotionally dependent on the third country national parent. An entire dependency was a phrase used in paragraph 44 of the AG's opinion. So that's how it finds its way into the case in that way. Paragraph 63, I should just highlight, I won't go through it all, but at the beginning of paragraph 63, and this is 647, in this connection, the court has already held that there are very specific situations in which, and so on and so forth. So specificity to the fore again. There's a reference, 5 lines from the end of 63, to obliged in practice. And in paragraph 64, situations referred to have the common feature that although they're governed by legislation falling within the competence of the member states, namely legislation particularly on immigration matters for third country nationals, which provide for the grant of such a right under certain conditions, those situations nonetheless have an intrinsic connection with the freedom of movement and residence of a union citizen, which precludes the right of entry and residence being refused. So the notion of an intrinsic connection with free movement, again, this comes back to what it is that really the Zambrano right is there to protect against. So that's the background, as I say, to what is then set out in terms of guidance in paragraph 70. And what follows in paragraph 70 in my submission is a requirement to identify two things in order to decide whether the child in question would be compelled to leave. First of all, one needs to identify and determine which parent is the primary carer. Of course, that is against the background of the court endorsing in paragraph 68 the approach in O of looking at the question of who has custody of the child. And secondly, one then needs to determine whether there is in fact a relationship of dependency between the child and the non-EU parent, and whether it is such a relationship of dependency that the child would in practice be compelled to leave. And in my submission, what follows in the remainder of paragraph 70 and 71 is guidance on the matters to take into account in determining that question. One notices from these passages that, of course, paragraph 68 of Dept wasn't referred to, which is the family unity provision. But that's unsurprising, because whereas Dept was a family unit case, Chavez-Vilches, of course, wasn't. So there could be no suggestion that the test has been in some way watered down. And then, of course, the third question referred was also very much about process and guidance, because it was looking at who bore the burden of demonstrating the existence of the right in question.
Can you help me? Paragraph 70, whatever else it's saying, is
Yes.
saying you do have to have regard to the Article 7 of the Charter of Fundamental
Yes.
Rights, which is exactly what the Advocate General was saying you don't have to do in one of the earlier cases we looked at.
Yes.
So there's a clear distinction, which is why I find it difficult to see why we're being taken back to the
Yes.
Advocate General's.
Well, my Lord, in my submission, the way to reconcile those two instances of Article 7 being raised is that in the earlier case, or in Dept and O, the point being made is that the desire to keep the family together cannot in EU law give rise to a right to reside in itself.
No, it's more subtle. At some point I'd like to see how you apply this to the Shah case. We're talking in general terms, but you've got
Yes,
to
of course.
show that in the Shah case the tribunal made an error of law.
Yes.
But don't do it now, we'll come back to it when convenient, but
I'm grateful.
I'd find it very helpful to...
No, my Lord, of course. In my submission, what the court is saying that you can legitimately use Article 7 for here is to examine whether in fact there is a relationship of such dependency between the third country national and the child that the child will be compelled to leave. So to recall, the first question in paragraph 70 is who is the primary carer of the child. I pause there to say I agree with Mr. Drabble, the language is slightly old-fashioned, to put it one way, but it's in another way not surprising because this was a situation with one parent with the child and the other parent being absent. That's why it looks at primary carer. But what the court is saying is to determine what the relationship of dependency is between the child and the parent, you can do that through the prism of Article 7 of the Charter. What you can't say is that a desire to keep the family together, a desire to maintain...
No, but take the Shah case, the primary carer is the father.
Yes.
The mother is a breadwinner.
Yes.
On the other hand, there's clearly an element of dependency with the mother, and if you look at the family relationship, they go together. So surely the easy answer from all that is you take a broad view and do what the tribunal did in this case.
Well, if that were the case, then the Zambrano right would cease to be the highly protective but relatively exceptional right that it is at the moment. And actually, many of these cases would succeed, and that doesn't appear to be the court's intention. One looks at the way that it's framed the right and the language it's used. But, my Lord, moreover, there are situations, absolutely, where there might be a family unit case, where there may be, and there will be, difficult choices to be made. There will be an impact on the position of the parents. In the Shah case, it may be that the mother either has to give up work or potentially has to work reduced hours, may have to look at alternative caring arrangements if the father leaves. But the situation in those cases, unless the parent can show that the impact is such that the child has no realistic alternative but to go with the third country parent, in my submission that doesn't give rise to the Zambrano right. I can come to deal with that in a little bit more detail when I go through Shah towards the end of my submissions, but that in my submission is the position. And that reconciles the role that Article 7 is seen to play in Chavez-Vilches and in the earlier cases.
The difficulty that one has reconciling these is that in the earlier cases, they seem to be saying, oh yes, Article 7 is relevant once you've decided that the Zambrano right exists.
Yes.
Whereas this seems to be saying, obviously the Zambrano right depends upon dependency,
Yes.
and Article 7 is relevant in deciding whether there is a dependency.
Yes.
It is difficult to reconcile those two. That's
Yes.
Very clear.
Well, my lady, I entirely understand that point. To take the other example then that my ladyship's just given me about the earlier case law saying, well, Article 7 is relevant once you've decided that EU law is in play. That would cover, for example, a situation with a Rendon Maran case where you have a third country national parent who's being removed because of serious criminality. So in that situation, on the face of it, prima facie, one has a Zambrano right engaged because the third country national parent is perhaps a sole carer of the child in question. There's no other parent on the scene at all. And so if the third country national parent is deported, there is no question but that the child will go with them, all other things being equal, of course. In that situation, EU law is engaged because one knows a Zambrano right would otherwise exist. The question is whether one can derogate from it. And that was the issue that faced the Court of Justice in the CS Morocco and Rendon Maran cases I've already referred to. Now, that doesn't arise here. But in my submission, that is one way in which those earlier passages in the case law make sense. And of course, at the stage at which the court was saying that and making that point in Dept, for example, it hadn't yet given its judgments in CS Morocco and Rendon Maran. But they would be one explanation of how that works. I'm sorry, my lady.
I was going to say, I was saying that when to take account of the child's interest presupposes there may be circumstances in which you cannot give the child's interests priority over what immigration law requires.
Absolutely. And that is, in effect, the finding in CS Morocco and Rendon Maran. So that there are circumstances, and the approach of the Grand Chamber in those cases was to say, in effect, you apply Articles 27 and 28 of the Citizens Directive on exceptions to free movement, restrictions on free movement. By analogy with the position under the Citizens Directive, you apply them by analogy in an Article 20 situation as well.
But that doesn't take us away from this point that the inquiries being made in paragraph 70 on their face look as if they're different inquiries from what we've been concerned with before. For instance, investigating who is the primary carer and considering Article 7.
Well, that, my lady, that would be, again, referable to the particular facts of Chavez Vilches as compared to Dept. So with Dept, there was no issue but that there were two parents present. Certainly in Dept, it was slightly more complicated because there was another third country national parent in the situation. But in Dept, you had two parents, very like in Shah, one third country national, one EU citizen. And it was quite clear, relatively clear, what the relationship of dependency was. In Chavez Vilches, you have a situation, you have a number of different cases with the role of the other parent varying enormously between them. In one case, the parent wasn't even in the Netherlands anymore. In another case, they were themselves in institutional care. In yet other cases, they said they wanted to have nothing to do with the child. And in other cases, they had some degree of contact. So what the court is doing in my submission in paragraph 70 and 71 is recognising that there are a variety of factual scenarios that play out in these cases. Indeed, one only needs to look at the basic facts of the cases this court has been taken to today to see that the full variety of situations in which family life arises have played out before the European Court as well. And what the court is seeking to do in a necessarily broad way is to say you're going to have, member state courts and authorities, you are going to have to determine, first of all, who is the parent with care, and then you look at questions of dependency.
Is there, I'm sorry, I must have missed it. Is there a case which is like the Shah case, in which you've got a united couple of parents where the third country national is the primary carer and the EU citizen is the breadwinner? I don't think any of these cases are about that situation.
My lady, the closest is Dept, but I entirely accept that the caring responsibility...
There was absolutely nothing in Dept to
no.
Make it apparent that Mr. Dept was the person who was actually looking after these children.
No, my lady, I entirely accept that, but he was present in the family home. He
Yeah,
was still
but
a
that's-
subsisting family
Our
unit.
case is different.
Yeah, my lady, I accept that, of course. When I make the comparison between Dept and Shah, or between O and Shah, the contrast, if one likes, is with the Chavez-Vilches case, where the parents are simply not present. But I entirely accept there is a reversal in the caring responsibilities there. I accept that, of course. But then that is why it's important in Dept that there was an emphasis, both in the Advocate General's opinion and also in the court's judgment, as there was in O, endorsed again here in Chavez-Vilches, on the need to examine whether there was a right of residence for the other parent who was involved in the family situation. My lords, that's what I was proposing to say about Chavez-Vilches against that background at that stage.
I think you could have said something else in answer to me too.
My lady, I'm sorry, I'll try and do that. I'm sorry.
Well, I'm only mentioning it because obviously we don't have findings of fact to this effect,
No.
so this is pure speculation. But it could be possible that the fact that the father, Mr. Shah, did not have the right to work was the reason why he was the person looking after the children, and his wife was going out to work to support the
Yes.
family, rather than the other way about.
My lady, that is absolutely right.
But
And
it's pure speculation.
well, it would be speculation, my lady, which
I'm sorry, I am listening to you. It's just that my machine's...
yes, no, well, Ms. Smart has very
tendency to
helpfully
go to
given me a
sleep.
pointer to something which I can perhaps show you, ladyship, to make good that point. It's the first tier decision in Shah, core volume MS 431, and paragraph 12 makes it clear that your ladyship's point is not mere speculation, it's absolutely correct. Paragraph 12, from the totality of the evidence emerged that the appellant lives with his wife and British citizen child, who's approaching 1.5 years in age. Since the appellant is without any leave in the United Kingdom, he has no permission to work, and in fact he does not work. So because he didn't have
Well-
leave, he couldn't work.
I mean, that stands to reason.
Yes.
It doesn't say what their position would have been had he had it.
No, my lady, that's absolutely right. That's absolutely right. And so at that stage, the sort of difficult choice that later has to be made if he is removed or if he departs doesn't have to be made because, in fact, he can't work. The choice has to be made at a later stage. They've arranged themselves in that way. Well, my submission, it's a reasonable inference that they've arranged themselves in that way because of the legal constraints on his ability to work.
But we could be being very sexist about it, couldn't we?
Oh, I certainly wouldn't want to do that, my lady, and I don't want to equally don't want to take the point too far and be too opportunistic about it. I take it no further than what is in paragraph 12. It's a legal point about permission to work and no more.
But you, just before you went down into that subject, you said there was an emphasis on the need to examine the right of residence of the other parent. But you have to ask yourself why. And is it not arguable that why you look for the right of residence of the other parent is to see whether or not that other parent is able/willing to look after the child, which is a new inquiry?
My lady, that is, in my submission, right. That then goes to inform the analysis of dependency and compulsion to leave. So one has to look at the right to work of the right to reside of the other parent, because that will inform the tribunal in this difficult assessment of fact as to what in reality is going to happen. Is there going to be a situation where the child is compelled to leave? So take a Zambrano situation, if you have two parents, neither of whom, a pure Zambrano situation, neither of whom have a right to reside or to work, then of course the child has to leave. But where the other parent does have a right to reside and therefore a right to work, it may be possible for the child to remain and there won't be any compulsion to leave.
But Mrs. Shah could say, I am unwilling to look after the child because I cannot do so on my own.
Yes, my lady, she may say that. Of course, at that stage, one has to analyse whether, in fact, that response takes proper account of any assistance that may be available. So there may be family support in some cases. There is, of course, the fact that there may be alternative caring arrangements. In some cases, a parent may need to rearrange their working responsibilities, their working hours. And, of course, ultimately, there is the possibility of welfare support in particular cases. These are all situations which can be taken into account in determining whether one's in the exceptional territory of having a child who's compelled to leave. And they're difficult choices. It's never been part of the Secretary of State's case not to recognise that those are difficult choices to make, but they still remain questions of choice. And that was something that the Court of Appeal recognised here. My lords, my ladies, can I then move on to the case of KA? Again, this is one that you've seen already today, so I can move through this hopefully relatively swiftly. It's a Grand Chamber decision, and to answer my Lady Hale's point this morning, the decision in O was the second chamber. So it's the second chamber of the Luxembourg Court. KA is Grand Chamber again. It's at Volume 1, Tab 8, MS 730. Learned friends already referred you to the facts so far as they are relevant on page MS 731, H3. Don't seek to go through those again. Consideration of Article 20 begins in paragraph 47 of the Court's judgment, and that's MS 778. The first important passage at paragraph 65 on MS 781, so this is under the heading, the existence of a relationship of dependency capable of justifying a derived right of residence under Article 20, so that's the issue the Court was considering. Paragraph 65, the Court refers again to Zambrano and concludes this, 3 lines up from the bottom: an adult is, as a general rule, capable of living an independent existence apart from the members of his family. It follows that the identification of a relationship between 2 adult members of the same family is a relationship of dependency, capable of giving rise to a derived right of residence under Article 20, is conceivable only in exceptional cases, where, having regard to all the relevant circumstances, there could be no form of separation of the individual concerned from the member of his family on whom he is dependent. And there's some more analysis of the particular facts of the case. I pause there. In my submission, quite clearly, in this passage, the Grand Chamber sets a very high threshold for an adult Zambrano case to succeed. It's conceivable only in exceptional cases, and there must be no form of separation possible, having regard to all the circumstances. Now, whatever else one says about superimposing tests of exceptionality, that is nonetheless a very high test, however one wants to phrase it. In my submission, it wasn't met on the fact of the Patel case here. There will, of course, be cases where it is met, and the Court's seen perhaps one of those today in the MS Malaysia decision, the recent decision of the Court of Appeal, Volume 2, Tab 25. I don't seek to take the Court back to that, but it's quite clear that there will be some cases where that does succeed, but they will be few and far between. The second reason, though, why this is relevant is that the Court then does go on to look at not only the position of adult dependence, but also the position of child dependence. So it gets back into classic Chavez-Vilches or Zambrano territory. That consideration begins at paragraph 70 and onwards. The Court begins by repeating the Chavez-Vilches terminology. I note at this stage it does so in relation to the child cases. It doesn't do so in relation to the adult cases which precede this part of the judgment. So that answers the point, I think, made by my learned friend Mr. Rowe as to whether Chavez-Vilches applies to adult cases. Paragraph 71 and 72 repeat the guidance in Chavez-Vilches. Then at 73, the Court says, accordingly, the fact that the third country national parent lives with a minor child who is a union citizen is one of the relevant factors to be taken into consideration in order to determine whether there is a relationship of dependency between them, but it is not a prerequisite, and it refers there back to the O decision. So insofar as O was not a Grand Chamber decision, it's certainly endorsed at least to this degree and further on as well in this passage.
What does it mean by prerequisite there?
Well, there may be cases where a third country national who's not living with them could succeed.
Well, that would be really quite dramatic, wouldn't it?
It would, but it demonstrates the need to take particular account of the particular factual circumstances. These are cases which turn intensely on their facts, and all the Court is doing there is saying you can't rule out completely the fact that there might be a relationship of dependency which is sufficient if the parent isn't there. It's very difficult in practice to see how that would actually work and what sort of case would succeed. And the court doesn't assist by giving any further guidance on it. That appears to be what it's saying. But then, at paragraph 74, one sees the reasoning in Dept and now again repeated, and this is also extremely important. On the other hand, the mere fact that it might appear desirable to a national of a member state for economic reasons or in order to keep his family together in the territory of the Union, for the members of his family who do not have the nationality of a member state to be able to reside with him in the territory of the EU is not sufficient in itself to support the view that the Union citizen will be compelled to leave the territory of the EU. Such a right is not granted. That, of course, is paragraph 68 of Dept, paragraph 52 of O. Concludes by saying the existence of a family link, whether natural or legal, between a minor citizen and a third country national parent cannot be sufficient ground to justify the grant under Article 20 of a derived right of residence to that parent in the territory of the member state, which the minor is a national. So in my submission, there can be no suggestion that Chavez-Vilches, or indeed KA, have diluted the importance of paragraph 68 of Dept. It didn't feature, as I say, in Chavez-Vilches because it was a different subset of cases, but it's repeated here. It's quite clear the Grand Chamber is maintaining that mode of analysis. My ladies, my lords, can I bring then my submissions...
Sorry, I'm not quite sure I understand. So, to the extent that it's saying that the mere fact that it might be desirable for economic or family reason to keep them together and so on is not enough.
Yes.
I mean, that bit of Dept is maintained.
Yes.
But the sort of more nuanced analysis which we find repeated in paragraph 71 of this judgment, you don't find in Dept.
I'm sorry, I
You
missed
don't find in Dept.
No.
Paragraph 71 is pure Chavez-Vilches,
Yes.
and it seems to me a rather different approach to Dept. So you're keeping one element of the Dept analysis, but not that very stark analysis, no doubt because the facts being considered rather more varied.
Well, my lord...
The dispositive in paragraph 76, is the second bullet,
Yes.
is actually very helpful. I think it's drawing the distinction between the existence of a family link,
Yes.
which is not enough,
Yes.
even though it might be desirable to keep the family together,
Absolutely, my lord.
but a relationship of dependency is necessary, and that depends upon all the various factors which are listed in the first part of that bullet.
My lord, absolutely. But my lord, as part of that, though, with the Dept test, the part of the Dept test, the Dept approach that's maintained in paragraph 74 is, in my submission, the absolutely critical part of Dept, because it shows the importance or relative importance of issues of family unity. And that's consistent in my submission with the second part of the dispositive in paragraph 76, second bullet. It's absolutely consistent with that. So, my ladies, my lords, can I then summarise where I've got to so far on both the pre-Chavez-Vilches case law and Chavez-Vilches and KA itself in 5 submissions? First of all, as I began by saying, the Zambrano right exists at the very edge of EU law because it doesn't depend on prior exercise of free movement. Instead, it protects a potential future exercise of free movement rights, which are the core of the rights possessed by an EU citizen. For that reason, it only arises in exceptional and specific circumstances. That's still as true at the stage of KA as it was in Zambrano itself. Secondly, the exceptional nature of a Zambrano right is particularly illustrated in cases involving adults, where the court has confirmed that it's only if no form of separation is possible that a Zambrano right will arise. Thirdly, in my submission, the court has maintained its analysis that the desire to keep a family together or financial factors are not enough in themselves, not sufficient in themselves, to establish a Zambrano right. So that's also consistent with paragraph 76 of KA. Fourthly, in cases involving children, whether family unit or single parent cases, the factors in Chavez-Vilches have to be considered in order to determine whether the relationship of dependency between the EU citizen child and a third country national parent is such that the child would in fact be compelled to leave. That's what Chavez-Vilches gives. It's a framework for analysis. And I've explained how, in my submission, Article 7 of the Charter plays into that. And then fifthly, it's always relevant to take into account that there is another parent who can care for the child, even if that may mean they have to adjust their personal circumstances. That's necessarily highly context-specific. In the type of cases considered in Chavez-Vilches, this wouldn't be a weighty factor because the degree of connection with the other parents was generally very sparse. But in a Derechi or O style case, it's highly significant because the other parent is living with the family and heavily involved, potentially heavily involved in the lives of the children. My ladies and my lords, so far I've focused on the decisions of the Luxembourg court. There are, of course, a number of decisions in this jurisdiction examining Zambrano as well. I wasn't proposing to take the court to them specifically for the simple reason that the issue in the case is whether or not Chavez-Vilches has changed the playing field. That's the core issue in these cases, and a number of the decisions at domestic level predate Chavez-Vilches.
And I don't think there's a decision at this level
No.
that really is of any great assistance.
My lady, that's right. The decision in HC...
It's about something completely different.
It's about something different. It does post-date Chavez-Vilches, but the issue is not the same. It's about benefits and exclusion from benefits for Zambrano carers. We do say there's some guidance given in those cases. Can I just give the references to the court, but I won't ask the court to turn them up. So the first one, HC, as I've mentioned, is Volume 1, Tab 3, MS 566. And the paragraphs that we say are relevant there would be paragraphs 9, 11, 13 and 15 in my Lord Carnwath's judgment, and paragraphs 43 to 48 in my Lady Hale's concurring judgment. There's also an analysis of Zambrano in this court's decision in Aguiarco, which is Volume 1, Tab 1, MS 510, paragraphs 61 to 68, Lord Reed giving the judgment. And then there are three decisions of the Court of Appeal. First of all, FZ China, Volume 2, Tab 21, MS 991, paragraphs 15 and 16 in the judgment of Lord Justice Longmore, with whom my Lord Sales and Lady Justice Gloucester agreed. Secondly, decision in VM Jamaica, Volume 2, Tab 29, MS 1208. My Lord Sales gave the judgment in that case, paragraphs 55 to 57, and 60 to 63. My Lady Arden agreed. And then finally, of course, you've already had some reference to the Harrison case, which is Volume 1, Tab 2, MS 538. Relevant passages there are paragraphs 19, 21, 63 to 69 in Lord Justice Elias's judgment, with whom Lord Justices Ward and Pitchford agreed. As I say, I don't seek to go to them in any detail at all. My ladies and my lords, that's my stage 3 of the analysis, so examining Chavez-Vilches and KA. Can I then follow it with just a brief response to some of the interveners' points about the Charter in particular? Mr. Patel, of course, relies on Article 25 of the Charter, the rights of the elderly. He's supported by Liberty, who also rely on Article 26 on the integration of persons with disabilities. I don't ask the court to turn to those provisions, but again, for the court's note, they're found in Volume 1, Tab 18, MS 962 to 963. Liberty's submissions are summarised in paragraph 1.4 of their written case in core volume MS 215. As we understand it, they seek to make 2 points. First of all, As regards adults, they say the question of what compels a citizen to leave the EU must be informed by the rights of a disabled adult to independent living, autonomy and dignity. And secondly, as regards children, the question of what compels them to leave must be informed by an understanding of their best interests and whether they are compelled to leave in order to maintain family unity. As well as the Charter, they also rely on the UN CRPD and the UN CRC. That leaves the Air Centre, who make 2 points, again as we understand it from their written case and what they've said today. They say, first of all, that the Court of Appeal's analysis is inconsistent with Chavez-Vilches. Well, we say not. I'll explain why in a moment when I come to the Court of Appeal's judgment. And secondly, their second point is that the question of compulsion has to be looked at from the perspective of the child. Well, I can deal with that briefly now, as I've said. Certainly you have to look at the perspective of the child, of course, because one's concerned with the impact on a child's best interests, amongst other things. But it's not the only aspect of the analysis, and one has also to look at the position of the parents too. That's our short response to that point. Before I go further in responding to Liberty's analysis, can I just make some key points about the approach to the Charter? And some of this I've already covered with the debate on Article 7. The starting point, and we said this is uncontroversial, is that the Charter cannot be used as a tool to expand the scope of EU law. We've set out the references to the relevant provisions in paragraphs 61 to 64 of our written case at MS 199 to 200. And of course, I've already taken the court to the analysis in Dept, where that's examined. So this means that in the Zambrano context, there must be a compulsion to leave, and the Charter cannot be used as a tool to expand the scope of the Zambrano. There is no such compulsion. The other key point to make about the Charter is that it distinguishes between rights and principles. Principles need to be implemented by legislation. Even within the scope of EU law, principles are incapable of giving rise to specific individual rights. Reference to authority for that is in the explanations to the Charter on Article 52. And again, I'll just give the court the reference. Volume 1, tab 20, MS page 990. And as we've set out in our written case at paragraph 66, Article 25, is a principle only, and the same is true of Article 26. My ladies, my lords, against that background, can I turn then to Liberty's two central propositions? And there's two key points for the purposes of dealing with them. First of all, the test of compulsion is applied in such a way that it's only where no form of separation is possible in an adult case that a Zambrano right will exceptionally arise. So whatever else is said about the approach to compulsion in the Charter, that is the test as we know from KA. Of course, in applying that approach, secondly, the Grand Chamber did make it clear that one has to take into account all relevant circumstances. And so, stepping back from the matter, in one sense, one can see that matters relating to independence, autonomy and dignity are in the most general sense relevant. It would be difficult to argue the contrary, but they're not in any sense determinative, and they don't undermine the need to establish compulsion. Can I then make 4 points in response to Liberty's argument in this respect? As regards, first of all, the UN CRPD, the Grand Chamber of the Luxembourg Court has already held in clear terms that the rights it contains are not directly effective. That's a decision in the Z against A case. And that's at volume 3, tab 37, MS 1495, paragraph 90. That's because the provisions it contains are not sufficiently unconditional or precise to have direct effect.
Well, that'll be a relief to a lot of people,
My lady.
given some of the contents of that
Quite.
convention. Yeah.
Yes. And my lady, of course, that the reason is because they are so general and ranging, the rights in question. That's why they couldn't possibly have direct effect. And the same point was made in the Glatzel case as well, volume 2, tab 32, MS 1299 at paragraph 69. So in that context, the need to interpret measures of secondary legislation so far as possible consistently with the EU's international obligations cannot assist for that simple reason. And we say secondly that the lack of precision and conditionality of those rights is in and of itself highly significant. The notions of independence, autonomy and dignity which the interveners rely are plainly not themselves unconditional or unlimited rights. There may be relevant factors in assessing a dependent adult's position, but they can't realistically be determinative on their own. Thirdly, importantly, of course, as I've tried to show from the case law, the Zambrano right only arises in any event in very specific circumstances. There has to be compulsion leading to a loss of EU law rights, otherwise EU law is simply not engaged. So just as the scope of the Zambrano right cannot be expanded by the Charter, so it can't be expanded by the CRPD. Fourthly, this is particularly relevant to the position of adults. In this jurisdiction, at least, there is, of course, a very well-developed and established system of welfare support, where necessary, including residential care support. That's a system which is provided for all lawful residents of the United Kingdom. There are many British citizens who, because of their own particular circumstances, perhaps a lack of family care available, have to rely on residential care provisions in the welfare state. So in our submission, although that might well not be the first choice of the family, it plainly isn't the choice of the Patel family. And again, Mr. Patel is only to be commended for what he's doing. It doesn't show that there is a situation of compulsion in existence.
Nobody's really suggesting that the existence of social care for children should prevent a Zambrano right arising, are they?
No, and my lady, you may recall there was some discussion of that in the Harrison case. There was an express concession by the Secretary of State that, for example, putting the child up for adoption would not be an alternative. Now,
Putting the child into care. Yeah.
Well, then, what I was preparing to say was there may be some situations, for example, with a much older child, and the Court of Appeal looked at this in a case called AQ, which isn't before the court, but where you have a child perhaps aged 16 or 17 years old who would be eligible for support under the leaving care provisions, and you may have other family members who can assist. There may be circumstances there where some sort of social care or social welfare support may be of assistance in meeting the needs, particularly in the very short term. But again, that would be quite an unusual case. It is a situation which occasionally comes before the tribunals, and the Court of Appeal in the AQ considered it something that had to be considered, but it will be relatively unusual. Certainly, the paradigm situation of adoption, which the court was considering in Harrison, is not something which is proposed.
Well, Harrison, adoption is an extremely extreme solution. There are other ways of arranging for other people to look after your children.
Yes. And my lady, one of the issues that's come up is, for example, the position of grandparents. Now, in an ordinary case, you can't simply say, well, you can parachute in a grandparent to carry out the parent's responsibilities without some understanding of why that might be appropriate. But of course, there are some situations where the parent who would otherwise have care may, for example, be in prison, may lead a particularly chaotic lifestyle. Again, these are factors which the court has examined. And it may be appropriate in some cases for alternative family members to provide that assistance in loco parentis, as it were. But it's not going to be an ordinary situation. It's not going to be the usual situation. My purpose in making that point is just to make clear that there are cases where it is appropriate. But again, highly specific, turn on their facts. My ladies, my lords, that really is what I was proposing to say about the position of the interveners. Obviously, Liberty have only made their representations in writing, so you haven't had oral submissions from them today. But that, in my submission, is how to respond to that position. That leaves then stage 5 of my analysis, which is the application of the law, as it were, to the present case, and in particular, whether the Court of Appeal has erred in the approach that it's used. Can I just ask the Court to begin by taking up the Court of Appeal's judgment, which is in the core volume, MS 251, behind tab 10 of the appendix. And there are really two passages that need to be looked at just briefly. The first is MS 264. And this is where Lord Justice Irwin, with whom Lord Justice Lindblom and Lady Justice Thirlwell agreed, really summarises the position post Chavez-Vilches. Paragraph 25, MS 264, he says, it seems clear that the underlying principle in Zambrano is understood by Chavez-Vilches, albeit that in the case of a child dependent on one parent, who's a third country national with no right of residence, the state must ensure a careful process of inquiry. However, the third country national bears the evidential burden of establishing that the child citizen will in practice be compelled to leave the EU unless rights of residence are granted to the brackets principal carer parents. He then moves from that conclusion, which I say is wholly accurate, to examine the facts of the individual cases. So first Shah, he simply sets out the facts and submissions to begin with, then Baruisa, and then Patel. And his conclusions, the court's conclusions, are begin at MS 275, paragraph 72. It begins by saying this: in my judgment, the decision in Chavez-Vilches represents no departure from the principle of EU law laid down in Zambrano. Well, it does constitute a reminder that the principle must be applied with careful inquiry, paying attention to the relevant criteria and considerations, and focusing not on whether the EU citizen, child or dependent can remain in legal theory, but whether they can do so in practice. There's no alteration to the test of compulsion. So a pause there. That, of course, is consistent with an analysis which says it's not just about whether, in theory, you could remain. You actually look at the practice as well. You look at the practicalities. And over the page, he concludes at 74 that there's been no sea change in the law and that the existing domestic authorities hold good. He recognises the impressive evidence of the strength of family life in paragraph 75 in the Shah and Baruisa cases. He says every sensible person would wish to honour the impulse of the mother in the Shah case. However, recognition of that does not alter the fact that however hard such a choice may be, it is a choice, not a necessity, not compulsion. In my judgment, the evidence in each of the two cases is clear that where the British parents remain, they would be able to care for the children concerned perfectly well. The child's citizen would be under no compulsion to leave the EU. Now that then flows into an analysis in paragraph 77 about the particular position in Shah and Baruisa. He says he'd allow the appeals, and in each case, it seems to me, the tribunal started with the desirability of maintaining the family life and jumped to the conclusion that there was the requisite compulsion on the child. In my view, that was an error. The correct approach would have been to ask, is the situation of the child or children such that if the non-EU citizen parent leaves, the British citizen will be unable to care for the child or children, so the latter will be compelled to leave. And then this, importantly, in doing so, the tribunal must pay regard to all the relevant circumstances indicated by the CJEU in Chavez-Vilches, in particular, paragraph 70 to 72 quoted above. So in my submission, he does lay emphasis, rightly so, on whether there would be an alternative carer available if the third country national had to depart. But he does so squarely through the prism of the guidance in Chavez-Vilches. He focuses on the existence of an alternative carer because, of course, these were family unit cases. That's why he starts from that position. But in my submission, it's wrong to say that he in some way ignored the Chavez-Vilches guidance. He didn't have to set it out in any more detail. He set it out in full before. He applied it then to the factors found by the tribunal. And in paragraph 79, he says the question of compulsion did not really even arise. If one parent left, each parent would be perfectly capable of looking after the child. No real evidence to the contrary. There would have been a loss of earnings, diminution of material things, an important loss of two parents living together with their child. But as the evidence stood, there was no proper basis for a finding of compulsion. He refers to the Article 8 claim in Shah and Baruisa it's not been made. He doesn't close that off. Against that background, can I just look at what it was the tribunals found in those two cases before I come back to the Patel case. So the FTT decision for Shah, first tier tribunals, at page 429. And the relevant paragraphs begin on MS 432. paragraph 15 is really the important starting point. Having considered the totality of the evidence, it seems to me as a matter of fact that although the appellant's wife, being the child's natural mother, plays an important role in the child's life, the primary responsibility for the child's care does fall on the father. Then 4 lines up from the bottom at the end of the line, the mother does, however, get involved in the child's care till she returns home from work and obviously stays with the child, as does the appellant, throughout the night until the routine starts again the following day. She is also the main breadwinner in the household. However, whilst that's a factor to be taken into account, it's by no means decisive. We say that must be right as well, given the situation with rights to work and so on and so forth. Then at 17, this is really the reasoning for finding the Zambrano right arose. The next question I have to determine is whether if the appellant was not permitted to remain in the UK, the British citizen child would have to leave this country. In this regard, I take into account what the appellant appears to be in a happily married relationship with his wife. She appears to be willing to take on the mantle of providing the family's financial needs, forsaking her duties as a mother to nurse her young child. When she was asked what would happen if the appellant was not allowed to stay in this country, she replied that they would have to move as a family. I have no reason to doubt the sincerity of that statement. 18, if, as I find to be the case, the appellant's wife will wish to move with him to Pakistan, then the question remains whether the child would have to leave also. Bearing, of course, his young age, he concludes that he would. Now, my ladies and my lords, in my submission, there is an error of law there because the first-tier tribunal judge moves from finding that the appellant and his wife are in a happily married relationship and that she wishes to move with him if he is removed, to finding that there is in fact compulsion. What the judge doesn't do is examine whether the nature of dependency between the child and the father is such that the child is compelled to leave. That's the critical stage of the legal reasoning, even on the Chavez-Vilches analysis, which is omitted there. In those circumstances, and the upper tribunal essentially endorses that reasoning approach, the upper tribunal's decision is at page 423, but I don't seek to go to it in any detail. In those circumstances, in my submission, the Court of Appeal was quite right to say that that was an erroneous legal approach, and it was quite right also to say there was, in fact, no true evidence of compulsion. There was nothing beyond the mother saying she wished to leave. That may be an entirely sincere statement, and nobody's suggesting it's anything other than sincere. It doesn't show compulsion, though.
Because there was no investigation of other possible ways of caring for the child?
No investigation of the impact, actually, for example, on the child's best interest, if the child to remain with the father. With the mother. And there was no evidence referred to in the tribunal which could justify any other conclusion.
But was it put to her by the Secretary of State's representative that she could cope in other ways?
I'm sorry, was it put to
Was
her?
it put to her? I mean, was that case you're now put in to her?
My Lord,
I've got to look at the decision and
Yes.
light of the way the case was put before.
I have to accept there's no evidence that that was put in cross-examination. I have to accept that. Can't suggest otherwise.
Well, you have to contrast that wish to leave in paragraph 18 with what is said about the cross-examination at paragraph 7. The appellant was not allowed to. They will have to move as a family.
Yes, my Lord, I have to accept that. There was, and I also accept, as my learned friend pointed out, when he went to the case early this morning, the Secretary of State was represented, so I'm not suggesting that there was an exploration of this issue by the Secretary of State. I have to accept that. Nonetheless, in my submission, the situation on the facts and on the evidence was still insufficient in those circumstances and subject to that limitation on the Secretary of State's, the way the Secretary of State put the case, to reach the finding that the tribunal did at paragraph 17. My Lords, my Ladies, that's the Shah case, and what I was going to say about that. That leaves Patel.
And can I just
Yes.
clarify? If one goes to page 420, one sees the Lord Justice Voss giving reasons for allowing an additional ground of appeal on the term primary carer. And there was an issue, or at least there was thought to be an issue, about whether the
Yes.
husband was the primary carer. But when one comes to the actual judgment of the Court of Appeal, that's not pursued by the Secretary of State, is it?
No, that's correct. And the statutory provisions in the regulations have changed since then.
I see, okay.
So the reason that wasn't pursued, there was initially an issue about whether you could be a primary carer if you shared care equally.
I see.
And the regulations as originally drafted, the 2006 regulations, said that if you shared care equally with somebody who was not an exempt person, so in other words, it wasn't somebody with another right to reside, then you couldn't succeed under Zambrano. That position changed in an amendment to the 2016 regulations.
Fair enough. Thank you.
Grateful, my Lord. If your Lordship wants the reference, we deal with that in, this is the Secretary of State's skeleton in the Court of Appeal on Shah, MS 476 to 477. That explains how that came to be.
Yeah. But that doesn't affect the issues under
No.
Zambrano.
That's not a live, it's not been a live issue since the Court of Appeal itself. That's absolutely right. So that is why I say that the Court of Appeal was absolutely right to find an error committed by the tribunal in the Shah case. As regards the Patel case, again, just going back to the Court of Appeal's analysis, this begins on MS 277. The analysis begins in paragraph 80. And in paragraph 82, it further seems to me that the evidence in this case was too equivocal to amount to compulsion. However one looked at the matter, there was absolutely no doubt as to the parents' devotion to their son or his to them. Were he to leave to India, there was no doubt that the parents said they would follow, despite the findings below, but that really represented their cultural and individual commitment to each other. That again is choice, not compulsion. Objectively, paragraph 83, the choice was and presumably still is a difficult choice. The evidence was there was no house existing, no extended family in India. That presumably means selling up in Britain and a transfer of resources to India. Part of the appellant's case was that medical facilities would be more limited in India, as I've indicated above. However, remaining in England, the parents will be faced with medical and social care support that's likely to be lesser in quality, certainly more impersonal, than that provided by their son. The Tribunal Judge Hanson considered on the evidence he heard, it was inevitable the parents would in fact remain, but even if that were wrong, the situation can in no way be regarded as one of compulsion to leave. There's then an examination in paragraph 84 of the circumstances in which such a case on an adult situation might succeed. Those are just examples of situations where it might do. But the critical issue was, on the evidence before the tribunal, the tribunal itself didn't accept that the parents would in fact leave if the son left. And the reason was because of the very different situation in India. Can I just take the court to the relevant parts of, first of all, the first-tier tribunal decision in Patel. The relevant passages begin at page MS 301. Can I just highlight a few parts here? In paragraph 17, first-tier tribunal just begins by saying that the appellant provided further evidence establishing that the care provided to his father from social services wouldn't be at the same level that he provided. He says, I accept that evidence, but this is not a case self-evidently where the appellant's father would have no access to support if he wasn't present. He records the appellant's argument that his father would have no option but to leave the UK if the appellant wasn't present in the country to continue to care for him. But the appellant's evidence is that the family has no family home in India, which is the country where the appellant would have to go to if he left the UK, nor does he have any siblings or any other family members in India able to offer accommodation and support. And there's a reference to the father saying his life would be finished if the son departed. Paragraph 18 is reference to the mother's evidence of what she would do if the son left. Paragraph 19, the appellant's submission is that if he had to return I think that should be to India, his father would feel compelled to join him and therefore leave the United Kingdom. To establish that submission, therefore, the evidence must show that his father would choose to return to the country where he and his son would be homeless and without family support. Further, there's no evidence of what level of medical care, if any, would be made available to the appellant's father in India and the timescale of that provision. And there's further analysis of those points. And then 6 lines up from the bottom, the fact of the matter is that the medical needs of the appellant's father can only be secured with any confidence by remaining in the United Kingdom rather than going to India, and I'm simply unable to accept his father and mother would not see that as the reality of his situation. In all those circumstances, therefore, I'm not satisfied that the appellant has proved his father would be unable to reside for the purposes of the regulations if he left. So my submission, what that is a very careful analysis of the facts by the first-tier tribunal judge, correctly analysing the situation here and in India if the father were to return, and analysing what in those circumstances would actually occur.
This was being said in June 2015. We assume that the factual position is the same today, do we?
There's certainly no updating evidence before.
And I just wonder, it's obviously not directly relevant, but
Yes.
has any thought, do you know, been given to Article 8? I mean, I know it wasn't pursued initially, but it does
Well, there was in the Patel,
strike one as a potential.
yes, there was in the Patel case an Article 8 claim that was dismissed.
Yes.
So in the 3 cases before the Court of Appeal.
No, I understand it was dismissed, but that wouldn't prevent it being considered again. I'm just
No, of course.
whether any thought, you're aware whether any thought has been given to it more recently.
No, as far as I'm aware, and I'll be corrected if I'm wrong, there's been no, for example, further submissions, but I'm looking across the bench, and no, I don't think there has. So there's been no further submissions made on Article 8 grounds. Of course, there's nothing to stop that happening. I want to be seen to be inviting that by part of the Secretary of State, but it's possible that that could happen. And of course, one of the issues that's already been explored today in argument is that in some situations, Article 8 may be a more appropriate mechanism for protection than Zambrano under EU law. That, of course, was the case for Mr. Buruisa, who succeeded on an Article 8 claim he made after the Court of Appeal's judgment in this case. So, my ladies and my lords, in my submission, entirely lawful and proper approach to the analysis of the facts, the careful analysis required by the case law carried out by the first-tier tribunal there, the upper tribunal effectively endorses that analysis. And really the key part in the upper tribunal's determination at MS 294 is in paragraph 32. The tribunal says there's no removal decision against the appellant's parents, and the issue is that of a constructive expulsion argument. To hold the fact that the parents want their son to remain and continue with the current family and care regime is determinative would be to base the decision on subjective elements only. The judge was required to examine critically a claim that a British citizen will leave the Union if the benefits he currently receives by remaining in the United Kingdom are unlikely to be matched in the country in which he claims he will be forced to settle. The judge did so and found the claim the appellant's parents would leave the UK not to be credible or plausible. That is a finding open to the judge on the evidence. My submission, that is plainly right. There's no error of law in the first-tier tribunal judge's analysis, or indeed in that part of the upper tribunal's analysis. And for that reason, the Court of Appeal was quite right to dismiss the appeal that then came forward. My ladies and my lords, may I just have a moment to turn my back? My ladies and my lords, 5 minutes ahead of time. Those are my submissions, unless I can assist any further.
I think you have answered everything thrown at you. Whether satisfactorily or not, only time will tell.
Ready, I'll wait and see. Thank you, my lord.
Thank you.
Lady, I've got, I think it's about 7 points. Don't hold me to that in reply, but I'll try and get through them in about 10 minutes flat, if I possibly can. The first point in reply is that I submit we don't need to knock down the straw man of proving that Chavez Vilches constituted some sea change in the law at the Luxembourg level. It's adequate for our purposes that it develops, refines, perhaps unpacks the implications of what was already there, but at any rate makes clear what needs to be done in a case where a Zambrano right is contended for. Secondly, I noticed in the course of our learned friend Mr. Drabbles' submissions, his phrasing about inability to remain in the European Union if the non-EU person is removed. He spoke in terms of whether a situation is to be regarded as one in which somebody is forced to leave, whether or not to describe it as a situation in which the EU citizen is forced to leave the EU. And in my respectful submission, that's an appropriate approach to take. It echoes the submissions I was seeking to make earlier about how it's really a somewhat arid exercise to look at this solely in terms of this being only a factual question without acknowledging that under the surface there may be judgments to be made. Thirdly, my learned friend Mr. Blundell emphasised the very dogmatic Dutch rules. He was in reference to the case of Chavez-Vilches, the very dogmatic Dutch rules that were under consideration there. Really, as if this was a point in the Secretary of State's favour, but in our submission, it's rather a point in our favour, because the court could have said simply, well, look, the test is whether you're forced to leave, and you're not allowed to import this mechanism which effectively answers that question without looking at the facts. That's all the Court of Justice had to say in the Chavez-Vilches case. But it didn't say that. It pronounced, perhaps somewhat ex cathedra, but it did it all the same. It pronounced what it pronounced. And it's not really, in my submission, for this court to seek to read that down or to construe it narrowly or look at it in a narrow context. Those paragraphs that we've been taken to, that the court's been taken to by counsel on all sides, lay down a clear scheme which is applicable to cases where it's necessary to consider whether somebody will be unable to remain in the Union.
Just on that.
Yes.
If one looks at paragraph 59 in Chavez-Vilches, where the court says what question is being asked, this is at MS page 646.
Yes, I have it.
It did seem to me to have something of the flavour that the court, in its judgment in the O case at paragraph 56, appeared to be endorsing what the Advocate General had said at paragraph 44 in O, where he talked about entire dependency. And so I wondered whether the particular context for Chavez-Vilches was the court examining to what extent one could go back to the Advocate General, in other words, whether the court in its judgment at paragraph 56 was to be taken to have endorsed that part of the Advocate General as well. Answer, no, it's not as strict as that, and you have to examine the underlying circumstances in what's been emphasised to us was a single parent case, but with someone else potentially on the sidelines.
Well, that may be right. I mean, in a sense, I've been suggesting that we shouldn't look at. I've been saying that Chavez-Vilches is a response to the Dutch scheme, but it may be that, I don't know, it may be the Dutch scheme itself is a response to some perception as to what the law was in the light of O. I don't know.
Well, that's what I wondered, because if you read the Advocate General's opinion in O at point 44, it looks extremely strict.
Yes, but it doesn't. That may be right, but it doesn't deprive my point, I submit, of some force, which is that the court did not need to go as far as it went in Chavez-Vilches. It didn't need to lay down this scheme as to how the court ought to address these questions. It could simply have said, no, it's not a sufficient answer, that there exists somewhere somebody who's prepared to take this person on, and that's it. Which essentially was what the Dutch scheme said, and perhaps what the Advocate General might have been understood to have said. My lord, my lady, rather, my fourth point was just in relation to KA, and our learned friend emphasises the phraseology there. It has to be a case where no form of separation is possible. That actually, I submit, drifts a little away from the language of de facto forced to leave. It rather supports our point, we would submit, that, as I've said, it's a somewhat arid exercise, simply to ask yourself, well, will the EU citizen be forced to leave? No form of separation is possible, necessarily looks at it in terms of more of a value judgment about that separation. Of course, as a matter of fact, separation is always possible. the state always has the power to separate the person who can be removed from the person who is not being removed because he or she is a citizen. So the question really, one might say, is whether it can be contemplated in the particular circumstances. It merely adds force in my submission to the point that this is not simply a question of asking yourself, well, in a very literal sense, unable to remain, forced out. Is it a case where that's the state of affairs? It's also not the position, I would respectfully submit, that KA says, oh, our adult cases are cases in which none of the Chavez-Vilches stuff applies. That's not what the Court of Justice says. On the facts of KA, the adult cases never got very far, for the reasons that we looked at briefly in the course of my submissions in opening. There simply was very little evidence there of any real dependency. But the Court of Justice doesn't go further to say that in all cases involving adults, it limits the cases of adults by in the sense that it points out that they're likely to be unusual cases, which is perfectly understandable as a matter of fact, because that's exactly what they're likely to be. But it doesn't.
The court seems to say they're an exceptional category within an exceptional category. That's how I rather took it.
Well, I mean, it provided that one doesn't put too much weight or the wrong sort of meaning on the term exceptional, I'm not sure I would quarrel with that analysis. If by exceptional one means that Zambrano itself is an exception,
that's what
general position.
Yes.
Yeah, and if by exceptional in the context of adults one means that one generally doesn't come across situations where one adult is dependent upon another to the necessary extent, then I accept that it's an exception within an exception. But none of that ought necessarily to lead in, or none of that ought to lead to a mindset when thinking about these cases that this it's really extremely unlikely that you're ever going to succeed, absent some really florid set of facts. That's
in
not.
Para 76, or as my lady pointed out, on page 783, KA does seem to suggest a pretty clear-cut distinction between children cases and non-children cases.
Well, my lord, it does, but it does not exclude from the adult cases what logically must apply in any case, because there's no logical reason to make them to have a cut-off between adults and children. I mean, it's an incomplete statement, I suppose, in a sense. It makes the perfectly fair point that in an adult case, a relationship of dependency capable of justifying the grant, etc., is only conceivable in exceptional cases, and explains what is said, what are meant by exceptional cases. But it doesn't exclude what logically must be right, which is that even in a case where it is an adult, if you're seeking to ask, well, is this one of the cases within that category, you have to perform the analysis that is set out in Chavez-Vilches about looking at the extent of the dependency, and I'll come on in a moment to what I say that analysis should be and what it should have been in the present case. My lady, our fifth point concerns the Charter and other instruments, and we do rely and adopt gratefully. I didn't speak to this in opening, but we do rely and adopt gratefully what Liberty say in that context. We agree, of course, that the Charter in principle can't be used to expand the scope of operation of EU law. But our learned friend for the Secretary of State says, well, there must be compulsion before the Charter is engaged. But that can't be right in our respectful submission in the light of Chavez-Vilches, which is very clear that in considering the question of whether there is a risk of compulsory departure from the Union, in other words, whether there is compulsion, in considering that, you have to look at the Charter. In that context, it was Article 7. So it's not consistent with Chavez-Vilches to say, well, you can just ignore the Charter altogether and set it to one side. You can't, in our respectful submission. It's said against us, well, in relation to the parts that we rely upon, these are principles rather than rights. Well, that would be fatal if we were asserting a positive right to remain under the Charter, but we're not. Our case is simply that as part of the broader, multifaceted, more nuanced exercise which Chavez-Vilches requires, keeping in mind those principles which are set out in the Charter is an important aspect. So whether it's a right or a principle, that can't affect the force of those matters as being relevant. My sixth point was simply to endorse your ladyship's point that no one suggests that the availability of social care provision, state provision of some sort, provides an answer in children's cases, and nor should it, should one suggest that. But nor in our submission should it be suggested that it provides necessarily an answer in an adult case. It's not, if it can't be a trump card in one case, it can't be a trump card in another. It doesn't provide an automatic answer. And yet we do submit that the first tier tribunal decision does come pretty close, read as a whole, to saying that that was the Secretary of State's principal submission, according to the way it's set out in the FTT decision. Well, there is always social provision. That's not a sufficient answer. And maybe finally, just to deal in reply with what is said about the facts. Well, what should have happened in the first tier tribunal, and what might the outcome have been if that had happened? That's essentially the way we put it. The answer in our submission is what should have happened in the first tier tribunal and didn't happen, partly in fairness to the judge because Chavez-Vilches hadn't been decided at the time. But what should have happened is a detailed assessment, as dictated, we submit, by Chavez-Vilches, even in an adult case, of whether there was and is a relationship of dependency between the EU citizens, here the parents, and the non-EU citizen, Mr. Patel Jr. The detailed and intense analysis of that, of the extent of the dependence, whether it was partial, whether it was total, what its features were, what its aspects were, and of what the risks of separation for the parents would be, picking up on the point in Chavez-Vilches in the children context about the risks to the equilibrium of the children. That would all have been informed by, had it been done properly in our submission, by detailed consideration, proper and detailed consideration, specifically of the evidence, in particular the care report and the psychological report. And that would have revealed, and it would have become the subject of findings on the face of the decision, it would have revealed the intense dependence, in this case, unusually so, the intense dependence of Mr. Patel Sr. And Mrs. Patel as well on their son. Mrs. Patel's unwillingness to leave the house, the whole extensive regime that you looked at in connection with the dialysis. And I emphasize this not for the point of, not for the purpose of seeking a further expression as to how admirably Mr. Patel Jr. is behaving, which is legally neither here nor there, but because it demonstrates in our submission the intensity of that dependence. And that would have led to a much more informed and explicit consideration of whether this was, to use the phrase used in KA by the court, a case where really no separation is possible. And in our submission, that's how it ought to have been done. And if it had been done, would the tribunal have found, as a fact, that the parents will not leave if their son leaves? Well, in our respectful submission, it might not have made that finding had it been approached in that way. And one cannot, in our respectful submission, at any rate, be confident that it would not have made that finding had it gone about things in that way. And if the tribunal had reasoned in the way that we suggest it should have reasoned, would it have concluded that any decision to depart would be a matter of choice rather than compulsion? Well, again, it might not have done, and one cannot be confident that it wouldn't have done. That's really the way that we put it. Instead, we respectfully submit that we haven't had, that Mr. Patel hasn't had the careful analysis that Chavez-Vilches requires, and in any event, the FTT decision, having alluded to the question of who's the primary carer, makes really no further reference to the detail of the evidence, which is important in this context. I accept, of course, that as a matter of fact, I've already, I think, more or less conceded this, cases where an adult can derive a right to remain in the EU from an EU citizen who is also an adult will be relatively rare cases. But our respectful submission is that Mr. Patel deserved a fair crack at persuading the tribunal that his was such a case. And we respectfully submit that he was not afforded that opportunity by this determination. And we invite this court to send it back so that he is afforded that opportunity. my lady. Those, unless there are questions that arise from any of that, are my submissions.
Do you have anything to say about why an Article 8 claim wasn't pursued? I mean, again, it's not direct.
As I understand it, an Article 8 claim... Can I leave my learned friend, Mr. Pennington, to deal with that? He's been involved with the case longer than I have.
Well, there was an Article 8 claim pursued in 2014 and rejected prior to the application for a derivative residence card. I have a vague recollection of there being some kind of resuscitation of that point at some point in the Court of Appeal, but I'm afraid I'm going to have to go off and see back at my notes and emails and find out exactly.
Well,
But
I mean,
I
you've
can't-
no
can't-
instructions presently. It's
Exactly.
irrelevant. Yes, thank you.
Thank you. Mr. Malik.
Three very short points. First, the cases that my learned friend for the Secretary of State has cited does not assist in my respectful submission on the facts of Mr. Shah's case. Unlike the cases cited, in this case, the third country national, that is Mr. Shah, is the primary carer with day-to-day responsibility for the child, and the British citizen mother is the breadwinner. Secondly, in his submissions, my learned friend for the Secretary of State suggested that the assessment of whether the mother would be willing and able to provide care for the child would involve consideration of matters such as any family support that may be available, alternative care arrangements, or different working arrangements. Now, these are matters that were not put to the mother when she was cross-examined at the first-year tribunal, and when she gave evidence that she cannot assume sole responsibility for the child. That, in my submission, was the Secretary of State's opportunity to probe these matters. In absence of any suggestion to the contrary, in my respectful submission, the first-year tribunal could not have speculated and was entitled to find that in this case, the child will have to leave the United Kingdom. Paragraph 18 of the first-year tribunal's decision must be read in the context. It was not merely a wish by the mother to reside with Mr. Shah. Her evidence was clear that she cannot assume sole responsibility and will have to. Now, if contrary to my primary case, the court takes the view that consideration of these matters is necessary, then in my submission, the appeal should be allowed with an order remitting the matter to the first-year tribunal for a fresh hearing. But my primary case remains that the court should restore the decisions made by the first-year tribunal and the upper tribunal. Third, my learned friend for the Secretary of State submits that the first-year tribunal's decision is wrong in law because there is no assessment by the first-year tribunal as to whether the extent of dependency between the child and the father is such that the child will have to leave the United Kingdom. But that assessment, in my respectful submission, is at paragraphs 6 and 15 of the first-year tribunal's decision.
Could you just give the page number again?
So sorry.
Oh, sorry, I didn't mean to interrupt you.
Six is MS page 431, I think,
Grateful.
and 15 is MS page 432.
I'm very grateful.
Thank you. Thank you.
So in short, in my respectful submission, it is unrealistic to say that a 2-year-old child who is dependent on the father to the extent found by the first-year tribunal at paragraphs 6 and 15, and whose mother made it plain in the evidence that she cannot assume sole responsibility, has any real choice. These are my submissions in reply. I'm grateful.
Thank you very much indeed, Mr. Malik, and thank you to everybody. Those from whom we have heard and those from whom we have not heard. We have nevertheless read what you have to say, and we will take it all into account and decide what the answer is to these difficult cases. Thank you all very much.